I can't pronounce this one very well, but I'll spell it for you. It says Lord, then the name is PENRHYIN. PENRHYIN. So the hello, are you there? Hello, hello,
Yes,
hello.
sir.
Okay. So that case is telling us that we cannot curtail that right that is conferred on the entailed tenant by virtue of the Section 1 of Fines and the Recovery Act of 1833. Now, it goes further to tell us that where the tenant is in possession, where that tenant is in possession, that entailed tenant is in possession, it can effect a transfer. Are we together? It can effect a transfer, fee simple estate, in the land to a purchaser without the consent of any person, provided that it's of full age, and that if the disposition is inter vivos, it does it by deed. If it does it by deed. So see further provision of section 15 and section 40, of provision of section 15 and section 40 of the Fines and Recovery Act 1833. So what I'm trying to say, in essence, is that you can do barring to enlarge your, entail estate to fee simple, which give you the unfettered powers to do what? To dispossess or to dispose the said land in fee simple, and it could do it also, it could also sell it for any lesser estate. That right cannot be curtailed, and any provision that makes it to be, impossible or disentailing will be a void provision. It goes further to tell us that, the tenant who is in possession, when he wants to do barring, he can transfer the fee simple estate in land to any purchaser without the consent of any person, provided that is of full age, and even though if it's of full age, if it's disposing the said estate by inter vivos, it must do it by gift. It goes further to tell us that where the tenant is not, where the tenant is not entitled in possession, when it's not in possession, when the entailed tenant is not in possession, he needs the consent of the tenant that is in actual possession. He must obtain the consent of the tenant in possession before he can pass the, before he can be able to sell in fee simple. Otherwise, he will not be able to sell to pass fee simple. What we pass is base fees. What he pass, it will be what will be base fees. So I've said about 3 or 4 things. I said you can enlarge your entail interest, by statutory conversion or by barring. And if you have to go by the barring process, you check the provision of Section 1 Fines and Recoveries Act of 1833, which gives the entailed tenant the unfettered power, to do what? To dispose of the land in fee simple, and then for any lesser estate. It goes further to say that that right cannot be curtailed, and therefore any attempt to curtail it will be void. And that where the tenant is in possession, he can effect this, transfer of fee simple, fee simple estate in the land to purchaser without consent of any person, provided that it's of full age, and if he's doing it by a gift inter vivos, it must be by deed. Also, it goes further to tell us that the tenant, where he's not in possession, he needs the consent of the tenant in possession. If he does the transfer without the consent of tenant in possession, what happens is that he will certainly be giving base fee. And then base fee estate that is transferring is limited in terms of period, because look at what it says. It says base fee is defined as exclusively that estate in principle into which estate sale is converted, where where the issues entail are bad. So what I'm trying to say is that the estate that you are going to be conferring on the purchaser is such that the estate will terminate if there is no descendants, if there are no longer issues, as opposed to what you should get if it is retail, whereby ascendant, descendant, and then people who have a collateral relationship with you can also inherit. So what we are trying to say is that your borrowing makes it possible for you to convert your entail interest into to enlarge into fee simple, and it's a right that cannot be curtailed. Attempt to do that will be void, and that if you intend to do that, if you are a tenant in possession, you'll be able to do it without, without the consent of anybody. But if you are not the tenant in possession, to convert retail to whatever, you must get the consent of the tenant in possession. If you fail to do that, what will be transferring is a base fee that they're going to be transferring, and base fee is practically less in value and in all other terms than fee simple. Now, when we talk about statutory conversion, we are saying that by virtue of Section 3 of the Property and Conveyancing Law 1959, which is applicable in the Old Western region and Midwestern region of Nigeria, including Oyo, Osun, Ondo, Ekiti, Ogun, Edo Delta, a limitation of fee simple estate, before or after the commencement of that law will operate as a conveyance of fee simple estate, absolute in possession. So what we are trying to say in essence is that by virtue of Section 3 of PCL of 1959, if anybody before or after the commencement of of that law is granted an entail interest, or is granted granted an entail interest, of retail, that the provision of Section 3 operates to do what? To convert that entail interest to fee simple, absolute. Fee simple, absolute. So what we're trying to say in essence is that those are the two ways by which you can convert, retail to, or by which you can enlarge retail to, by which you can enlarge retail to fee simple. Now, life estate is the next next in line in the doctrine of estate. When we talk about life estate, a life estate creates only life interest. It creates life interest in favor of the grantee. It will create only life interest in favor of the grantee. And it may be created in two ways. One, maybe by express limitation or by the operations of law. Of course, if you look at express limitation, it could be created expressly where the estate is limited in favor of, say, Idris for life, or in favor of Idris for life of Raufu. So, or you say that, it's in favor of John for life, or in favor of John for life of Raufu. So that is life estate that is created expressly. And then the other way by which life estate could be created, before the advent of land use act, is a life estate that will have been created by operation of law, consequent upon the ineffective creation, of a fee simple estate or a fee tail, by a grantor. So the purpose of this paragraph is that a life estate, creates only life interest in favor of the grantee. That is to use it for life, for the rest of his life. Or it could be created by express limitation or by operation of law. If it is created expressly, then the estate is such that it is limited in favor of Mr. A for his life, or in favor of Mr. A for the life of Mr. B. So now the other way by which life estate can be created is what, before the advent of land use, that is what we mean, is the creation of that life estate by operation of law. Operation of law arises where consequent upon the ineffective creation in the ineffective creation in law of a fee simple estate or a fee tail estate by the grantor, which will lead to life estate. So, for example, you want to create a fee simple in those days, and then you do not put the words of limitation like to A and its heir. That creation that you have made, which you are trying to use, which you did not do properly, would naturally that principle you are trying to create, which you didn't do properly, will be converted to what's it called? It will be converted to life estate. And same for fee tail. Same for fee tail. Remember that there are some words that cannot use. Are we together? Remember. So if you are trying to create fee tail and then you do use the appropriate words that you're supposed to use, depending on the region where you have created it, what will have ended up creating is life estate. So the point I'm saying is that life estate will arise by operation of law if you are trying to create, life estate, if you are trying to create fee simple or fee tail, and then you have not used the right word in creation of those, of those estates, and that estate you are trying to create will have failed, and then will more or less be result into creation of a life estate. Now, related to this rule of estate that we are treating is the case of wild case. Wild is spelled W-I-L-D-E. W-I-L-D-E. You have come across it a number of times in your okay, you are still doing equity and trust. Now you still come across it. Now, what this one is saying is that, it is saying that wild case is applicable here. It's saying that the rule in wild case is what we are going to learn now. And then it is applicable to the construction of a will, necessitated by the desire to give effect to the intention of the testator, who from the four corners of his testament intended the children of a named beneficiary, to benefit from a device. So the rule is that where a gift of land is made by testator in his will to Mr. A and his children, and A had no children at the time of this device, of course, the word children is prima facie construed as a word of limitation, with the result that A gets a fee tail estate. So what we are trying to say is that applying the rules of, the rules in Wild's case, when we are trying to do a construction of a will, assuming that Mr. B, or let's assume that Mr. Rufus made a will, which he made a gift in it, and then they want to construct, and then it says that it says in that will that he made a gift of land in that will to Mr. A and his children, and A had no children at the time of the device. What you mean is that the word children is prima facie construed as a word of limitation, with the result that A gets a fee tail estate. So the word of limitation, that word of limitation which is usually seen as and its heirs. They said that if it is will that is being constructed, and we are applying the rules in White's case, if the will is saying that I am giving a gift of land, I'm making a gift of land to Mr. A and his children, and at the time of the death of that man, at the time that gift is being made, the man had no children. The children that is used here will be seen under the wills law, under the construction of wills, making use of a White's case, will be taken as words of limitation. And then what that means is that the man will get, a fee tail estate. Put more simply, in a very simplified form, the construction of will as regards giving a gift of land, making a gift of land, and then what kind of estate it will confer, when it's relating to, when we're talking about doctrine of estate, is that if a man is giving a gift of land I get to my point, in a will and by a testator. And that at the time that that gift is being made, it says that they are making that gift to the man and his children. You know, what that means is that the man will take fee simple estate. The man will take fee simple estate if he had no children at that point in time. And the rationale for this is that the rationale for this rule, you know, is that it lies in the intention of the testator to benefit the children of faith. But since they were not in existence at the time the will was made, the children could only take through their father having an estate of inheritance. The children could take through their father who has an estate of inheritance. Think it again. It says the rule in Wild's case is a rule of construction of a will necessitated by desire to give effect to the intention of the testator, who from the four corners of his testament intended the children of a named beneficiary to benefit from a device. And therefore, the rule is that where a gift of land is made by the testator in the will to A and his children, and A had no children at the time of the device, of course, the word children is commercially construed as a word of limitation, will result that A gets a fetale estate, and the justification for this rule is that, you know, it is the intention of the testator to benefit the children, but since they were not in existence at the time the will was made, the children of A could only take through their father having estate of inheritance. So what this rule is saying, if I must repeat myself, is that in relation to doctrine of estate, and then doctrine of estate or estate which is created under a will, and then we are going to be applying the will's case to that interpretation of the clause that is creating an estate in that will. So if there is a clause in a will that is more or less, you know, saying that I give to A gift of land, I made to A gift of land and to his children, I get to my point, you know, and then, you know, what is going to be applicable in interpreting that part, that clause, is the rule in Wild's case, which says that if that gift is made to that man and his children, and at time the gift is made to him in that will, then it happens that the man did not have children. They say that what the man will have is fetale, because the only way his children can partake through their father is to have what they call the estate of inheritance. The only way the children can actually inherit through their father is for their father to have an estate of inheritance. Of course, they now tell us that where the beneficiary at the time of the device, you know, where the beneficiary had children, rather, where the beneficiary had children at the time of the device, the children is construed as word of purchase, so that, you know, the beneficiary and the children take as joint tenants of the entailed interest. They take as what? Joint tenant. They take as joint tenant. So what I'm trying to say in essence is that now, applying the rules in Wild's case to interpretation of the construction of a will, when an estate is created by a testator in that will, stating that I am giving this land to the man and his children, and then at the time that will is made, the man had no children, then because it is the intention of the man that the children should also inherit, and the result of this would be that if the man had no children when the will was made, the man will be given a fetale estate. Fetale estate will be given to him, to the extent that the meaning, to the extent that the justification for this is that the only way the children can inherit is, you know, if it is the intention of the testator that the children should partake in that gift, the only way they can inherit is for their father to have an estate of inheritance. But if they were both alive, the children are alive, the father are alive, the father is alive, at the time the estate is the estate is created in the will in their favor, they both will take as joint tenant. Remember all the rules of joint tenancy. There is unity of time, unity of estate, unity of what have you, and that you know that if one dies, the other one takes over. The estate goes to the other people who are surviving, and the rest of that understand the rules of jus accrescendi. Now, I'm not sure whether you understand the point I'm making. Did you get the point I'm making? Hello? Hello?
Right on,
Hello?
sir. Right on, sir. We can hear.
Okay. No, don't just write on. Did you understand what
No,
I
sir.
said?
Sir, please, can you go over the explanation of the rule in Wilde's case again? Sorry, sir.
Eh?
Please, can you go over the explanation of rule in Wilde's case again?
Hello? The Wilde's case again. Okay.
Yes, sir. Thank
Okay.
you.
I'll go to it again. Now, what I'm saying is that we are talking about doctrine of estate. We are talking about doctrine of estate. You know, gifts can be made in a deed. You know, the gift you are making can be an estate, and could also be made via deed or via will. So we're not saying that a gift of an estate, make a gift of an estate in a will, and that's your gift of an estate in that will. It's saying that you are giving to Mr. A and his children. You are giving to Mr. A and his children. Then what that means is that you want the children of Mr. A to also partake in that gift of land, in that gift of estate that you are creating in that will. But assuming that when the gift was made to Mr. A and his children, the children were not alive. He did not have children at that time. And what the law is saying is that on the applications of rule of construction contained in Wilde's case, the only gift, the only estate that can be created in favor of A by virtue of that clause is what is fee simple, because the only way these children who are mentioned in that will can inherit or can partake is if their father has an estate that is inheritable. Do I need to state it again? Hello? Hello?
Thank you, sir.
Hello?
Thank you, sir.
Do
Thank
I
you,
need to
sir.
state
I
it
get
again?
it now.
You now get
No,
it?
thank you, sir. Yes, sir.
Okay,
Thank
all
you.
right. For the sake of clarity, I'll state it once again that rules in Wilde's case is a rule of construction of a will. Now, you know that you can make your gift either by deed or by will. But if you now make a gift of estate, of a particular estate in a will, and then what you stated in that will is that A and his children should inherit that thing that you want to give to them. But unfortunately, at the time that that gift is being made, the man had no children. So the law is that applying the rules established in Wilde's case to constructions of a will, what will happen is that the man will have a fee simple, because the justification for this, hello? The justification for this is that the only way the children who the man intended they should inherit or partake of that gift, the only way they can partake of that gift, the only way they can inherit is by ensuring that their father, Mr. Hay, has an estate of inheritance. The rule in Wilde's case, upon use in interpretation of or construction of a will, also tells us that if the children were alive when the gift was made, then the two of them will own joint, will have joint, they'll be joint tenants. So now let us also apply the rule in Shelley's case. The rule in Shelley's case is also talking about gifts that are made, gifts of land or estate that is made. And then one, if a gift is made of a freehold to a man, and then the remainder goes to his children. The law is that the man can own that thing absolutely, and he can sell the estate. He can sell it. He can dispose of it. So that is the rule established in Shelley's case. So compare the two of them and note them, have them at your fingertips, so that when the examiner come in a very cunning way to kind of confuse you, you will not be confused. Rule in Wilde's case is telling us that when we are doing a construction of will or clause of a will in relation to estates in land that is created in favor of a man and his children were not alive, were not born, when the gift was made, it says that the man will have fee simple. And the justification for this is that the only way the children can inherit for him is for him to have estate which is inheritable. While the Shelley's case that if the man is giving fee simple and then remainder is given to the children, the man can sell off, he can dispose of it, before the remainder gets to the children. But this rule in Shelley's case, please note that this rule in Shelley's case that gives the man, to kind of prevent the remainder man from inheriting by giving him right to sell, even though it was freehold was given to him, or that even though a fee simple was given to him, and then the remainder is given to the children. This rule, which operates as a rule of construction of will and deeds, have been abolished. They have been abolished in states that are covered by Property and then Conveyancing Act of 1959. Look at section 147 of that law. Section 147 of PCL has abolished that rule in Shelley's case. So you need to note. Did I make myself clear?
Sorry, sir, can you repeat what you said? No, sir, it's not clear, sir.
What is not clear? Which one is not clear? Have you understood the rule in Wild's case?
Yeah, I understand the rule in Shelley's case. You were saying that the rule has been abolished by, I didn't get that side.
No, I have moved on to Shelley's case. Shelley.
Okay, Shelley, okay.
No, do you understand the rule in Wild's case? Do you understand the rules in Wild's case?
Yes, I understand the rule in that case.
I now move on to the rule in Shelley's case, which is also rules of construction. When we are talking constructions of a deed or a will, when we are talking about doctrine of estate, is that clear? Did you get that?
Yes,
Hello?
sir.
Okay,
yes,
now,
I can hear you, sir.
So what does the Shelley's case now tell us? Now, Shelley's case tells us that if a man has, a freehold estate by virtue of a deed or by a will, now, and the remainder is given to his children. I get my point. Now, what they are saying is that construction of that whatever, what we are trying is that the construction of that clause using Shelley's case is that one, the man has freehold estate, and the remainder is given to his children. I'm saying that the man during his lifetime can enjoy that freehold, and then he will sell it. He can dispose of it without any consequences. I get my point, without waiting for the remainder to come and inherit. So that is the rule in Shelley's case. The rule in Shelley's case basically applies to deed and will when we are talking about gifts that are made, gift of land made, or gifts of estate made in a will or in a deed. And when we are applying the rule in Shelley's case to it, it's saying that if a gift of land, if a gift of estate or whatever is made in a deed or in a will. Hello?
Yeah, I can hear you, sir.
We can hear you, sir.
Hello?
We can hear you.
Sir, we're not hearing you for some time now. So we can't hear you again. Oh.
Oh, I'm back. I'm back. Hello? Hello? Hello?
Yes, sir, we can hear you now.
Okay, please let's listen attentively. Do we understand the rules in Shelley's scale? Shelley's scale when interpreting when we are doing construction of a will in relation to a doctrine of estate. Have you understood that?
Yes, sir.
Have you understood that? Okay, now
Yes,
we
sir.
now move on to Shelley. We now move on to Shelley's case, and the Shelley's case is also a rule of interpretation. When we say a gift of land or a gift of estate is being made, either by deed or by will, what this one is saying in Shelley's case is that if a gift of estate is made, a gift of freehold estate is made to the man, and then the remainder to the children. Shelley's case says that the man, while he's alive, he can sell, he can dispose of that estate, even though the remainder is for the children. That's what Shelley actually provides. That's the way Shelley interprets a gift made to the man, and then a gift of freehold made to the man with a remainder going to the children. He says that in spite of the fact that remainder goes to the children, the man is capable of disposing of that freehold estate while he's still alive, and nothing goes Shelley. Nothing will happen. That is what Shelley is telling us. So, did you get that? Did you get that?
Yes, sir.
Yes, sir.
Okay. So
Yes, sir.
without leaving anything for the remainder man, who are the children, you could dispose of the property. I'm not saying that this rule of Shelley that is applicable when freehold estate is made to the father and children have remainder, which entitles him to be able to sell or dispose of it while he's alive, that rule, which operates as the rules of constructions of wills and deeds, has been abolished in PCL states by virtue of section 147 of the PCL. Are we together? Are we together?
Yes, sir.
Yes, sir.
Okay. So the effect of this is that if the rule in Shelley has been abolished here in Western region by virtue of PCL in section 147, it's not telling us that as far as the Western region is concerned, that Shelley that provides that if freehold interest is given to the father, Shelley's case that is telling us that when we are construing a will or construing a deed and a freehold interest is given to the father and remainder to the children, but the man is capable of selling the freehold interest without waiting for the remainder to inherit. That rule has been abolished by virtue of section 147 of PCL in the Western region and Midwestern region states. And then what that means is that if the estate is created such that, freehold estate is given to the man, and then, remainder is for the children, the father can only enjoy it for his lifetime. Life estate is now, life interest is created for the father, and the remainder will go to the children. That is as far as, the rule in Wild's case and then Shelley's case is concerned. I repeat myself because I know that that rule is always giving students of land law a bit of a problem. But in summary, in a way that you must not forget, is to tell you that when we are applying, rules in Wild's case to construction of a will, wherein a gift of estate has been made to a father and to the children, and the father does not have children at the time that the gift was made, the gift of the estate was made, what will happen is that the father will inherit a fee simple, because the justification for this is that the only way the children will partake of that gift, and then would there could be the manifest intention of the testator could be given meaning is by making the man to have an inheritable estate. But when the children are alive, when the gift was made, the two of them the father and the children will have what? Joint tenancy. Now, and I'll also let you know that the basic rule of interpretation that we brought out, that we learned from Shelley's rule, is that, you know, I don't know how to put it more clearly in English language. In our place, Shelley's rule is like saying that, Baba, the father, oh my jaye omo e motie, oh jaye omo e motitie. So, meaning that he lives his life, he lives the life of children along with his own. So now what happened in Shelley is that when we're applying that rule in Shelley to interpretation of deed or a will that is making a gift of estate, saying that the father will have, he will have a freehold estate and the children will have the remainder. The Shelley's rule of interpretation, when applied to that deed of will that is making that gift of estate, says that the man can sell and dispose of that estate and nothing will happen. Interpretation of will has been, abolished way back in 1959 in PCL by virtue of Section 147 in all the states where this law is applicable. And it says that where such is made, the man will not be able to sell, the estate while alive. He will only have life interest, and the children will be able to remain to inherit the remaining. Now we go on to modified estate. We go on to modified estate. Can I move on?
Sorry, sir, please, I have a question.
Okay, please go ahead.
Okay, so please, I would have to take you back to the wild case. I have just one question, sir, please. Is the estate of inheritance fee simple or fee tail? Because from my understanding, the children are the ones to inherit. So is it not supposed to be limited to the fee tail rather than the fee simple?
No. In the what the man has is fee tail and so fee simple. Sorry, I'm sorry. Oh, sorry, I've been mentioning fee tail. Oh, I'm sorry, please. The man gets fee tail. Please, I'm sorry. He gets fee tail. The children, the man gets fee tail. And then if they are alive, then if the children are alive, they both get what's it called? They both get joint tenancy. Please, I'm sorry. I mentioned fee simple instead of fee tail. So
Thank you.
I repeat again, for the sake of clarity, let me repeat again. Thank you for that observation that you made. It's fee tail, not fee simple. The man gets fee tail, and then the children will also get joint tenancy with him if they are alive when the gift was made. But if they are not alive when the gift was made, it will be fee tail on the justification that the children can only inherit from him if the man has an estate of inheritance. Thank you very much for that, for calling me to order. Thank you very much.
I have a question.
Now, okay, please go ahead.
Okay, it's still on the rule in White's case. I want to know the attitude of Nigerian courts with regards its implementation, because as I did my research, it appears to be as countries like US they don't use this rule anymore.
No, they don't use this rule anymore. Remember, we also told you the limitation to this study is that you are looking at them from the point of view that you are a solicitor, and these documents which were made before the advent of Land Use Act about 1978. Are we together? Hello?
I can hear you,
Hello?
sir.
Okay, so that if they come to your table, you should know the kind of interpretation you are going to give to them. Now, again, I'm not sure that those decisions in other jurisdictions, I'm not sure they will bind us, because what you find, what you learn in your legal system or legal method is that those jurisdictions over there, they move faster than us. I get to my point, and then their decisions in those other jurisdictions are going to be used as persuasive authority, not an authority that will be binding on us. But what I want to let you know is the fact that you also must bear in your mind that the essence of this study is to make sure that you as a solicitor, you as an arbiter at any point in time, any of these documents that were made in this language at the time before the 1979 Land Use Act came to sweep away all of those, interpretations, all of those applications, then you should know what interpretation to give them that will suit the situation, that will suit the position when it was made, or that will suit the circumstance relating to that estate when it was made. I'm not sure whether I made myself clear.
Yeah, I get you, sir. Thank you, sir.
All right, very much. Thank you very much. So we now still talk about, so please note very importantly that I was replacing, fee tail estate. I was replacing fee tail estate with fee simple. Please, I'm sorry. I was replacing fee tail estate with fee simple. So now we talk about modified estates. Now, when we talk about modified estates, a freehold estate may be granted upon a condition. That is when a modified estate is coming up. A modified estate is coming up when a freehold estate is granted either upon a condition or may be limited by a determinable event. So an estate becomes modified if a freehold estate is granted either upon a condition or it becomes limited by a determinable event. Becomes limited by a determinable event. Now, although both are limitations on the enjoyment of the freehold estate, the facts which distinguish one from the other may not be apparent to anybody who is unwary. So what I'm trying to say in essence is that the freehold estate may become modified where it is granted either upon a condition or it's granted upon a condition or it's limited by a determinable event. And that we are saying that both of them are limitations on the enjoyment of freehold estate, but there are facts that distinguish one from the other. Okay. Now, an interest upon a condition is that, an interest upon the condition is predicated upon an event, the happening or the non-happening of which the grantee's estate may commence or determine. I've said two things. Number one, please note very carefully that freehold estate may be granted either upon a condition or maybe limited by a determinable event. May be granted upon a condition or limited by a determinable event. Of course, the two of them, are whether determinable events, whether granted upon condition, they are both limitations. They are both limitations on the enjoyment of freehold. And then we should note that there are facts that distinguish one from the other. There are facts that distinguish one from the other. Now, an interest upon a condition is that, predicated, is that one that is predicated upon an event, the happening or the non-happening of which the grantee's estate may commence or determine. So when your interest is based upon a condition, then it means that it's predicated upon the event which must happen or must not happen, and then of which the grantee's estate may commence or determine. So I repeat myself that an estate upon a condition is that predicated upon an event, the happening or the non-happening of which the grantee's estate may commence or may be determined. Now, let us move on. Just follow carefully. Now, where the enjoyment of an interest may not commence until the event occurs. It is a condition precedent. It's a condition what? Condition precedent. So we are treating, interest upon a condition, which is said that is predicated upon an event, the happening or the non-happening of which will determine the grantee's estate commencement or determination. Now, where the enjoyment of an estate may not commence until some event occurs. This is called a condition precedent. But where the interest is to determine on the occurrence of some event, it is a condition subsequent. So when an interest is granted upon condition, it could be condition precedent or condition subsequent. Now, I repeat myself that where it is an interest upon a condition, it then means that it is predicated upon the event, upon an event, the happening or the non-happening of which the grantee may commence or determine, his interest. Now, it goes further to tell us that where the enjoyment of an estate may not commence until some event occurs, this is loudly a condition precedent. That's a condition that must happen. Now, but where the interest is to determine on the occurrence of some event, it is a condition subsequent. It is a condition subsequent. Of course, example of a condition precedent is where a gift is made to Mr. X. A gift is made to X and is asked when X is 21 years old, in which case his estate becomes operative only when, he fulfills that condition. And if A does not reach, if he doesn't reach the age of 21, what happens is that the gift is aborted. That's the condition precedent. That's a condition precedent in the, and when we talk about modified estate. Of course, also, when we say that a gift to Y on the condition, a gift to Y on the condition that he never.
Sorry, excuse me, sir.
Yes.
Please, sir, you were too fast. I didn't get anything on this and estate upon a condition.
Okay, I'll go back again. No,
Thank you, sir.
We're saying that we can modify that estate. An estate can, we say we can enlarge estate. Remember that the estate can be enlarged when we say by barring and by conversion. Can you remember?
Yes, sir.
Can you remember? Okay, and
yes, sir.
You still remember the rule of White's case that says that if a gift is made in a will, giving an estate to a man and to his children, and that when that will is made, the man did not have children, what will have is fetale. Yes, he will have fetale estate, because the justification for making him have fetale is that the only way children can inherit from him is for him to have an inheritable estate. And that if the children were actually alive when the gift was made, the construction of the will, using rules in White's case, is also that the children and the father will have joint tenancy. And then we said the rule in Shelley's case is this, that when we are interpreting gift of estate made in a deed or a will, and we're applying the rule of Shelley, whereby a freehold estate is given to the man, a freehold estate is given to the man, and the remainder is given to the children. The man can, by virtue of rule in Shelley, sell or dispose of that property, and then the remainder man may not have anything to inherit or to have. Now the rule was actually abolished by provision of Section 147 of PCL, applying to Western region and Midwestern region. And then we said that it now says that if that is the case, Shelley's rules of interpretation will no longer apply. The man to whom freehold estate is given will have life estate, and the children will have the remainder. Now, modified estate is saying that when we have a modified estate, now a freehold estate may be granted upon a condition or may be limited to a determinable event. A freehold estate may be granted upon condition or may be limited to a determinable effect. So what I'm trying to say is that when we are doing a modified estate, or when estate is modified, they are saying that when they give you a freehold estate, you may be granted that freehold estate based upon a condition, or that it may become determinable at the happening of certain, or may be limited in period by a determinable event. Now, we go further to say that the two of them, whether there's a determinable event, whether the freehold is granted, subject to certain conditions. Now, the two of them are more or less limiting the enjoyment of that freehold estate that has been granted to you. And then we now go further to say that in spite of the fact that the two of them are limiting the freehold estate, there are distinguishing factors that can make us to distinguish A from B. Now, did you get that? Can I move forward? Can I move forward? Hello? Hello?
Yes, you can.
Hello?
Yes, sir.
Yes, sir.
Okay, now, so we are still on modified estate, so that we don't confuse them. Now, we now went further to say that an interest, upon condition is the one that is predicated upon the, event, the happening or non-happening of which the grantee estate may commence or determine. So we are saying that if an interest is granted upon a condition, it then means that the commencement of that estate or the determination of that estate will depend on the happening or the non-happening of some events. It will depend on the happening or non-happening of some event. So I'm saying that in an institution where we have an interest upon condition, that means that that interest is predicated upon the happening of a particular event or the non-happening of that particular event. So what I'm saying is that if your interest is upon a condition, what that means that the commencement of that interest, the determination of that interest will depend on whether certain event will happen or certain event does not happen. Can I move forward? Can I move forward?
Yes, sir.
Yes, sir.
No, so those conditions, those events, those conditions that could be attaching to an interest in land could be condition precedent or condition subsequent. And then we are moving on to that condition precedent now. So we're now saying that for condition precedent, where the enjoyment of an interest may not commence, where the enjoyment of an interest may not commence until some event occurs. Enjoyment of the interest in that land may not commence until some interest occurs. Then what we have is a condition precedent. But where the interest is to determine on the occurrence of some event, then it's a condition subsequent, a condition subsequent. So condition subsequent operate to determine an interest. Conditions precedent operate to commence an interest. So giving an example of a condition precedent, we're now saying that a condition precedent is where a gift is made to X and its heirs when X is 21 years old. What that means is that the estate becomes operative. The estate becomes operative only when the specified condition is fulfilled. And what is that condition? And what that means is that if X never attained the age of 21, then the gift will be aborted. I'm not sure whether you understand me. That's why we stopped before you took me back. Can I move on? Can I
Please,
move
I
on?
have a question.
Yes.
I have a question. When you say the gift will be aborted, what exactly do you mean?
The gift will be aborted. That means the gift will fail. That means the man can never have the gift, cannot have that, freehold estate. Listen to it again. Listen to it. Remember that we are saying that when we are looking at estate, we are looking at how it is created in a deed and how it is created in a will. A gift can be made in a deed or can be made in a will. So if the freehold estate is made subject to some condition, now that condition will be condition precedent or condition subsequent. Condition precedent are those conditions that must occur before the man will start to enjoy the interest in land that is created in his favor. This condition subsequent means that those are the conditions that will occur that will lead to the termination or the determination of that interest. So I take you back again, and I say that when we talk about freehold estate, may be granted upon a condition or may be limited by a determinable event. So limiting by a determinable event means that something will happen that will mean that the event, that interest will be determined, will terminate. So we now say that the two of them, more or less, is a limitation on the enjoyment of freehold, but they have factors that could distinguish one from the other. And then we took the one that is interest upon condition as the one that is predicated upon the happening or the non-happening of an event, which which will lead to the commencement or the termination of the grantee's interest in the land. Now, we now went further to say that where the enjoyment of that interest may not commence, where it can never commence until some event has occurred, then what we have is a condition precedent. But where the interest will be determined on the occurrence of some event, that is what we call condition subsequent. So now, when an interest is granted upon condition, it could either be condition precedent or condition subsequent. Condition precedent is what should happen before the commencement of the enjoyment of that interest. Condition subsequent is something that will happen to determine or to bring to an end the enjoyment of that interest. And I mentioned to you that when we talk about condition precedent, examples cited here is that for example, a condition precedent is where a gift is made to X and is ours, but that he will take that gift when he's 21 years. That is, X will take that gift when he's 21 years old. In which case, his estate becomes operative only when he's satisfied that condition of becoming 21 years. If he's unable to get to 21 years before he dies, then the gift is aborted. The gift will fail. I'm not sure whether you are getting the point I'm making. Did you get that point?
I don't really. If the gift fails, and I'm assuming that the testator is dead, then where exactly does the interest in the estate go to? If it fails, if it's aborted.
Yes, if the gift fails, it depends on the provision that the man has made in his will. I get my point. He could have made room for residuary estate. In which case, if there's a clause for, we're talking about will now. If he made a rule for residuary estate in his will, then this gift that has failed will, for instance, fall into the residuary estate. It will fall into the residuary estate and it will be distributed according to the provision made in the residuary clause of that will. Are you getting my point? If, for example, we're talking about will, if, for example, he did not make room for residuary estate, and there's no residuary clause in his will, it then means that the man will have died tested in respect of those ones that he made provision for. And he probably will have died intestate in respect of the gift that has failed. Are we together?
Yes, sir. I get it. Thank you. Yes, I
Okay.
understand what you're saying. Thank you.
Okay, you understand now? Okay.
Yes.
Now, so the gift is aborted, it will fail. So now, again, a lot of scenarios can play out in this modified estate. Let's go on and see what other things that Professor of Law, Professor Smith, SCN, has to tell us or has to let us know in this under this subhead. Now, it says that a gift on the condition that he never sells it out of the family is an example of a condition subsequent. So remember that condition precedent that is one that will occur before you can start to enjoy it. The one that will determine it, if it happens, is considered condition subsequent. So if a gift is to A, you now make a gift to A on the condition that he never sells it out of the family, is an example of a condition subsequent. The one that will determine, that will bring to an end the enjoyment of that freehold, if it happens. So in this gift to Y, if he sells this outside the family, then that freehold comes to an end. So it says it will determine it. The first one says that it must occur before he begins to enjoy the estate. in which case X must be 21 years. But if he dies before 21 years, he cannot start the estate. The estate cannot commence. This one says that I give it to you, you continue to enjoy it. But the day you sell it out of the family line, then what happens then is that it will determine, it will end. So then the land will pass to Y upon the creation of the interest. It passes to him upon the creation of the interest, but it is liable to be forfeited if that condition is broken. Y therefore has a vested interest, liable to be divested when the condition attached to his interest operates in future to defeat his interest. So Y is saying that I will give you this estate. No, to Y they are saying I give you the estate, but you must ensure that it is kept within the family. The day you sell it out to another person, it becomes what? It becomes determinable. And then what that means is that it's a condition precedent. That's a condition precedent. Are we together? Are we together?
Yes, please, I have a question.
Okay.
When the land becomes determinable, what happens to it? Does it go back to?
Just calm down. We are getting there. Just calm down. Let's not be distracted. If you follow this, you get what we are saying. Just calm down. Just calm down. Now, a distinguishing feature. If at the end of this lecture I did not answer a question, that's what I've explained does not answer a question, please let me know. A distinguishing feature of an interest upon condition, is the presence of a separate clause of disfeasance which stands on its own and can easily be detached. This clause is like provided that on the condition that, but if it happens that and operates as condition subsequent. So what I'm trying to say is that one, when you have something like a distinguishing feature of an interest upon condition, which is that the presence of a separate clause of that disfeasance which stands on its own and can easily be detached, then that clause like provided that on the condition that they are good example. And I repeat myself that a distinguishing feature of an interest upon condition is the presence of a separate clause of disfeasance which stands on its own and can only be detached, thus like provided that on the condition that, but if it happens that they operate as condition subsequent. Of course, the test usually is whether the divisible condition is external to the words of limitation. Now, what we are trying to say in essence is that when you have an interest that is upon condition, then there must be a separate clause of disfeasance which could stand on its own and that can be easily be detached. And then when you begin to have provided that and on condition that and so on and so forth, what you have is a condition, is an interest upon condition. Interest upon condition. So those words likely to sound like provided that on the condition that they are what? They are interest. They are more or less describing interest that is, interest that is granted upon condition. Now, an estate on interest upon condition merely gives the grantor a right to re-enter. Please listen, you that you are asking what happened. You that you are asking what happened. Hello? Hello?
I'm listening, sir.
Okay, please listen. It says that an estate on interest upon condition merely gives the grantor a right to enter and determine the estate when the event occurs, and that the interest is not void ab initio on the failure of the condition, but only voidable at the discretion of the grantor. Failure of the condition normally vests the interest in the third party stipulated in the instrument. That is, the party stipulated in the instrument, creating the interest. Are you getting my point? And does not necessarily revert to the grantor. That is as far as when we talk about estate that is, more or less estate that is more or less granted upon condition. We're saying that when an estate that is granted upon condition, it gives the grantor a right to re-enter, and it becomes what? And then, it becomes possible for him to determine the estate when the condition occurs, such that the interest is not void ab initio on the failure of the condition, but only voidable at discretion of the grantor. And failure of the condition normally vests the interest in a third party stipulated in the instrument that is creating the interest and does not revert back to the grantor. Now, that is the point that we are trying to mention about a condition. Hello? Hello? Hello?
Yes, sir. We're hearing you.
Please give me 1 minute. So let me come back. 1 minute. 1 minute. Please, I'm coming. Let me come back 1 minute. Please let me wrap up before I go to attend to this pressing issue. Let me remind you of what I've just said today, and then please note where we stop today, so that we can be at the same page. Please note that a distinguishing feature of an interest upon condition is the presence of a separate clause of disfeasance which stands on its own and can easily be detached. I also mentioned to you that the clause like provided that on the condition that, but if it happens that they operate as condition subsequent. Now, I also let you know that the test is usually whether the divisible condition is external to the words of limitation. And that, please note, I want us to stop here so that I can deal with what I want to deal with, and then we can come back to it on Thursday. Now, estate of, an estate or interest upon condition will merely give the grantor the right to enter and determine the estate when the event occurs, i.e., the interest is void. The interest is not void ab initio, on the conditions, on the failure of the condition, but only voidable at the discretion of the grantor. Of course, the failure of the condition normally vests the interest in a third party. Please note it very importantly. It vests that interest in the third party that is stipulated in the instrument, creating the interest, and does not necessarily revert to the grantor. So what I'm trying to say in essence is that part of the distinguishing feature of an interest granted upon condition is that there is a presence of a separate clause of disputant that will make it to stand on its own, and that can be easily detached. Example of such, such separate clause of disputant include, provided that on the condition that, and that, if it happens that, which are more or less a good example of a divisible condition, which are external to the words of limitation. And then it goes further to tell us, that when an estate, the consequence of what happened, if that conditions happen, is what I'm stating here, that an estate or interest upon condition merely gives the grantor a right to enter and determine, the estate when the event occurs, or the interest, that is, the interest is not void ab initio on the failure of the condition, but only voidable at discretion of the grantor. It is voidable at the discretion of the grantor. And the failure of condition normally vests the interest in a third party, that is stipulated in that instrument, creating the interest, and does not necessarily revert back to the grantor. I repeat myself that the consequences is that an estate or an interest upon condition will merely give the grantor a right to enter and determine the estate when the event that has been stipulated as occurred. I.e., the interest will not be void ab initio, it will not be a void interest, it will not be a void interest ab initio, but on the failure of the condition, it will only become voidable at the discretion of the grantor. And the failure of the condition will vest the interest in a third party stipulated in that instrument, creating the interest, and does not necessarily revert to the grantor. So, summary of what we have done today is that we said that interest to be enlarged by barring, by statutory conversion. We learned the rule about Wells case. We learned the rules in Shelley's case. We learned the modification of the rules in Shelley's case by PCL section 47. We talk about modification, and then we are still dealing with interest granted upon condition, and that when interest, or estate granted upon condition, when it fails, it only gives the grantor a right to enter, and to determine the estate when the event occurs, and that the interest is not usually void ab initio. Please note that very importantly. That is the question that you are asking me the other time, that what happens in the event that those conditions they eventually occur, and that it gives the man, it does not make it void ab initio on the failure of the condition, but only voidable at the discretion of the grantor. And failure of the condition normally does what? Vest the interest in the third party that is stipulated in the instrument, creating the interest, and does not necessarily revert to the grantor. Please, let us note this point so that we can be on the same page when we meet on Thursday. Let me rush to get other things on this. Thank you very much.